5 justices of the South Carolina Supreme Court agreed on something last May. They wrote that a public official had, quote, placed her fingers on the scales of justice. That official wasn't a judge. She wasn't a prosecutor. She wasn't even a lawyer. She was the Clerk of Court, an elected administrator, the person who reads the verdict out loud. And because of what she did, the most watched murder conviction in South Carolina in a generation was thrown out. By the end of this video, you're going to understand something uncomfortable. That the trial didn't collapse because of the defendant, or the prosecutors, or the judge. It collapsed because of an administrative position most people don't know exists. And the system that was supposed to catch her looked the other way for over 2 years. One thing up front. The defendant, Alex Murdaugh, is still in prison. He admitted to stealing millions from his own clients. Those sentences are untouched. This video is not about whether he did it. It's about how a book deal broke a double murder trial. Becky Hill, everyone calls her Becky, was the elected Clerk of Court for Colleton County, South Carolina. Population 38,000. A rural jurisdiction where the courthouse staff knew each other by first name. Her job was administrative. She managed dockets, she kept exhibits, she organized meals for jurors. She read verdicts out loud in the courtroom. In a normal year, that job is invisible to the public. January 23, 2023 was not a normal year. That was the day the double murder trial of Alex Murdaugh began in her courthouse. Murdaugh was a prominent low-country attorney from a family of prosecutors. His wife and younger son had been killed in June of 2021 on the family's rural property. The state's theory was that he had done it. He was on trial for 2 counts of murder and 2 weapon possession counts. There was another woman in that courthouse who would later testify under oath about what Becky Hill said to her during the trial. A colleague, another clerk of court from a neighboring county, brought in to help with the crush of national media. She would tell a judge, 16 months later, that Hill talked about a lake house, about selling books, about what she needed the verdict to be. But nobody was listening yet. The trial lasted 6 weeks. It was televised nationally. Cameras in the courtroom, journalists from 3 continents, a rural clerk's office suddenly running one of the highest profile murder trials in the country. And in the middle of it, Becky Hill was taking notes. Not for the record, for herself. 6 months later, in July of 2023, a self-published book appeared on Amazon. The title was Behind the Doors of Justice, The Murdaugh Murders. The author was Becky Hill, co-written with a journalist named Neil Gordon. 15,000 copies sold, roughly $100,000 in profit. She and her husband kept about 65% of the royalties. And then 2 things happened, one after the other. First, in the fall of 2023, a juror from the trial came forward and told Murdaugh's lawyers that during the trial, Hill had made comments to the jury. Instructions on how to see the defendant. Told them, quote, not to be fooled by the defense evidence. Told them to watch him closely. At the start of deliberations, according to the juror, Hill said, quote, this shouldn't take us long. Second, in December of 2023, Neil Gordon, the co-author, discovered that 11 pages of the book's preface had been plagiarized, word for word, from a BBC News reporter named Holly Honderick. How did Hill get those pages? Honderick had accidentally emailed her a draft during the trial, meant for her editor, whose first name was also Rebecca. Hill kept the drafts and put them in the book. That was the moment the story stopped being about a book and started being about a trial. On October 27th, Murdaugh's lawyers filed a motion for a new trial. They alleged what they called jury tampering, and they named a witness who had been in the courthouse the whole time. The witness was Rhonda McElveen, the clerk of court from Barnwell County, next door to Colleton. She had been brought in to help Hill manage the trial. McElveen testified under oath in January of 2024 that Hill had repeatedly told her she wanted to write a book about the trial to buy a lake house, and that a guilty verdict would be, in Hill's words, the best way to sell books. The evidentiary hearing was presided over by retired Chief Justice Jean Toll. 3 jurors testified that Hill had made comments to them during the trial. 11 testified they had heard nothing. Toll, the same judge, asked jurors directly whether Hill's comments had influenced their verdicts. Most said no, and she denied the motion for a new trial. That should have been the end of it. It wasn't. 2 things then happened in parallel. In March of 2024, Hill resigned. Publicly, she said she wanted to spend time with her grandchildren and to give other Republican candidates time to file for her seat before the April deadline. Her attorney, Justin Bamberg, said the timing had nothing to do with any investigation. State prosecutors, at that moment, were actively investigating her. In December of 2025, Hill pleaded guilty. 4 charges. 1 felony count of perjury, for lying under oath to Judge Toll. 1 misdemeanor count of obstruction of justice, for leaking sealed crime scene photos to the media. 2 misdemeanor counts of misconduct in office, for paying herself almost $12,000 in improper bonuses from federal child support funds, and for using her public office to promote her book. And now the turn. She was never charged with jury tampering. Never. The state's special prosecutor, Rick Hubbard, told the court there wasn't enough evidence for a jury tampering conviction. The judge who sentenced her said if there had been, she'd have gone to prison. Instead, 3 years probation, 100 hours of community service, restitution paid by check that afternoon. 5 months later, the Supreme Court of South Carolina said something completely different. On May 13, 2026, the South Carolina Supreme Court issued opinion number 28,329. 5 justices, per curiam, unanimous. They vacated Murdaugh's murder convictions. They wrote, quote, "The breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina." They wrote that her interference was intended to push the jury to a guilty verdict. And they wrote that Judge Toll had made a legal error at that January hearing. Under South Carolina Evidence Rule 606B, you cannot ask a juror what was going on inside their head to decide whether external influence tainted a verdict. The test is objective. Did the improper contact happen, and could it have influenced an average juror? Once that's answered yes, prejudice is presumed, and the burden shifts to the state to prove it wasn't prejudicial. The state could not meet that burden. Now stop and see what has happened here. The judicial branch of South Carolina, unanimously, said Rebecca Hill's conduct was shocking jury interference that corrupted a double murder trial. The executive branch of South Carolina, the state prosecutors, said the same conduct was not provable as a crime. 2 branches, same facts, opposite conclusions. This is possible because of a structural feature that most Americans don't know exists. In South Carolina, the Clerk of Court is elected, not appointed, not supervised by the judicial branch. The judge presiding over a trial has no administrative authority over the clerk who runs it. Nobody, during the trial, was Hill's boss. And in a small rural courthouse suddenly running a global media event with a book contract sitting in the wings, the system that was supposed to protect the jury simply wasn't designed for what was happening in that room. I want to be clear about something. A trial did not collapse because of what the defendant did or didn't do. He is still in prison, by the way. 27 years in state, 40 years in federal, for financial crimes he admitted to under oath. Those sentences stand. A trial collapsed because a county administrator wanted to buy a lake house. And this is what makes this case worth caring about, whatever you think of Alex Murdaugh. Every high-profile trial in America is now a media asset. Somebody near it is going to be tempted. The bailiff, the court reporter, the person who reads the verdict out loud. And in most jurisdictions, the safeguards against that temptation are exactly what they were 50 years ago. Nothing. Elected officials with no supervisor. Rural courthouses that were built to handle traffic tickets suddenly running trials watched by 10 million people. But they also had to say it in 2026, about a trial that happened in 2023, about a courthouse where 3 years of denials and 1 book of plagiarized paragraphs came before anyone had the standing to reverse it. What's the point of a fair trial guarantee if the person running the trial is the one selling the story? If this is the first case where a court clerk's book deal broke a murder trial, tell me in the comments. Should the clerk of court be an elected position at all? Or should the judiciary control who runs its courtrooms? If this made you angry, that's the point. Channel it. Subscribe on this channel. We don't just accept the official story. If you want to keep flipping the script on the cases the whole world got wrong, there's always another side to the truth. See you Saturday.